All right, let's dive into something that really gets to the heart of our justice system. We're going to look at what happens when a victim's story isn't perfect, when it isn't a straight line. How does the law even begin to deal with the messy realities of memory, trauma, and time?
This right here is the big question. For the longest time, the thinking was pretty straightforward. If a story has holes in it, well, it must be a lie. But things are changing. The legal system is being pushed to look at this through a new lens, one that's actually based on what we now understand about the human brain.
So let's start with the first major hurdle the courts are trying to clear. What do you do when a person's account of a sexual offense seems to, well, change over time?
Just look at this contrast. The old way of thinking was basically a simple math problem. A different story equals an untrue story. Easy. But the modern approach, which is now being written directly into law in places like New South Wales, asks juries to wrestle with a much tougher idea. It says that, hey, guess what? Both true and false stories can have inconsistencies. It means those old, simple shortcuts to just dismissing a story, they're gone.
So, why this huge shift? Well, it's not just a new opinion floating around. It's literally being written into the law books. This quote from the legislation says it all. Experience shows trauma may affect people differently. The law is now forced to admit that trauma can do strange, powerful, and unpredictable things to a person's memory.
And when the law says differences, it's not just talking about one big, obvious contradiction. Nope, it covers the whole spectrum. Gaps in memory, little inconsistencies from one telling to the next, all those small variations. What's happening here is the law is finally trying to catch up with the messy, complicated truth of how our minds actually work when they're put under unbearable stress.
Okay, so it's not just about what a victim says, but also when they decide to say it. And this brings us to another old myth the law is trying to bust, the idea of silence. Why would someone wait, maybe for years, to report an assault? In some parts of Australia, judges now have a really clear, three-step job to do. First, they absolutely must warn the jury that a delay in reporting does not automatically mean the story is false. Second, they must tell the jury that there can be very good reasons for someone to wait. And this third one is so important. They must not even suggest that waiting to come forward makes a person's testimony dangerous or untrustworthy.
This line from Victorian law is wow. It's so powerful because it just takes a sledgehammer to an old, damaging myth. The idea that there's a right way to react to being assaulted. The law spells it out. There is no typical, proper, or normal response. It's basically telling the justice system, hey, you need to teach juries that there is no instruction manual for being a victim.
And here it is, the bottom line. For so long, there was this kind of unspoken historical bias in the law, a suggestion that people reporting sexual offenses were a special category of witness, one you had to be extra suspicious of. Well, the law now says no more. It explicitly forbids anyone from suggesting that complainants, as a group, are somehow inherently unreliable. That old stereotype is being kicked out of the courtroom.
So, if the rules are changing for witnesses in general, what about those who are the most vulnerable? Let's talk about the specific ways the system tries to make room for voices that can be the most difficult to hear.
In South Australia, the law gives us a very clear definition of a protected witness. This is for a young child or for a person who has a cognitive disability that makes it hard for them to give a clear, coherent story about what they went through. The law acknowledges that these witnesses need extra help to make sure their story can even be heard in the first place.
So how does their evidence get into court? Well, if they've made a statement outside of court, say to a police officer or a therapist, there's a careful process. The judge has to be convinced the statement has probative value, which is just a fancy way of saying it's reliable enough to be worth listening to. And this is key, the witness still has to be available to be cross-examined, but only if the court gives its direct permission.
Really, this whole thing is a balancing act. On the one hand, it opens up a path for crucial evidence to be heard that might otherwise just disappear. But on the other hand, it protects a cornerstone of our entire justice system, the right for an accused person to challenge the evidence that's being used against them. It's all about trying to be fair to everyone involved.
So when you put all of this together, what does it actually look like? Let's wrap this up by looking at the new toolkit the law's handing to juries to help them navigate this incredibly challenging job.
When you step back and see the big picture, you realize this is a seismic shift. The law is moving away from a default setting of suspicion and toward one of context. It's now telling juries flat out that trauma messes with memory, that inconsistencies don't automatically mean someone is lying, that a delay in reporting needs to be understood, not just judged. All those old, tired stereotypes are being actively rejected by the system itself.
Ultimately, the real engine driving all of these legal changes is a desire to move away from a justice system that was, for a long time, based on myths and stereotypes. The goal, the real mission, is to build a process that's actually guided by what we know from evidence about how human beings act, think, and remember.
The law can give juries a better map. It can give them better tools, a more informed, more modern starting point. But it can't give them the answer. Because at the end of the day, the law hands off the hardest job you can possibly imagine to 12 ordinary people. It asks them to sit in a room, look into the heart of another person's story, and decide what is true. And that will always be the most profound and deeply human challenge at the very center of justice.